Hello, this is Matt on the Moon Lambo channel. It's been a little while since we've gotten an update from Attorney John Deaton in terms of what's next for XRP holders, but that's the topic of this very latest Moon Lambo Hot Jam. For those of you looking at the screen, you can see there was a post yesterday from John Deaton's crypto law organization in which was posted the question, what's next for XRP holders? And this resulted in an article being created from the Crypto Basic titled Ripple v SEC, Deaton speaks on potential settlement, remedies, and appeal. And I gotta tell you folks, it's still an absolute war zone between the SEC and Ripple despite the major victory that we had in July last year. Oh my God, talk about scorched earth. In fact, the SEC is still up to sneaky, just completely disgusting maneuvers to try and gain dominance over Ripple, which is really a futile effort at this point by and large. But we're talking about the remedies portion of what's going on here. They're trying to get information from Ripple outside the scope of the actual lawsuit, outside the scope of the actual complaint that started this all back in 2020. It's disgusting. Just wait till you see the latest crap that they're trying to pull here. Also, a perspective that I'll be starting off with from attorney Bill Morgan. But before going further, I do want to be clear, I do not have a financial background of any kind. I am not offering financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so I'm going to start with what Bill Morgan has to say here. What he's talking about here absolutely is part of what Attorney John Deaton was talking about. And so this has to do largely with the fact that the SEC is seeking information about Ripple's institutional XRP sales that occurred after the date specified during the original complaint, which of course was filed, as you all know, December 22nd, 2020. That date's etched in my memory. I'm guessing yours as well. But the SEC has not amended the original complaint, so they can't go after those transactions. But here's what Attorney Bill Morgan had to say. Now that moronic FUD about the SEC v. Ripple case has started again, it may be time for an update on what is really happening. And then he's got 2 bullet points. Number 1, the matter is not about to settle. 2, on January 11th, the SEC filed a motion to compel Ripple to disclose its 2022 and 2023 financial statements and post-complaint since 12/20/20 contracts with institutions. And so, folks, this is what I'm getting at here. What in the ever-loving hell are they actually trying to do here? Are they going to get away with this? And then there was this post. The post continues from attorney Bill Morgan. He says, Ripple filed a response on January 19th arguing, amongst other things, that discovery of the post-complaint institution contracts would lead to a mini-trial of the legality of its post-contract sales to institutions. These will mostly be contracts with and sales to ODL customers, which I find it hard to fathom are investment contracts. On January 23rd, the SEC filed its reply, stating there would not be a mini-trial because it was not seeking a finding on the legality of post-complaint sales. It also said it was not a big deal for Ripple to discover the post-complaint contracts because Ripple had already cataloged and produced all post-complaint sales contracts to June 2023 in the Zakhanov v. Ripple case. And so, to sum it up a little bit here, what he's pointing out is that the SEC is demanding all of this extra information with all these transactions that occurred after the date of the complaint. And so Ripple's saying, okay, well, this might as well be its own damn trial then, effectively, right? And the SEC is insisting, no, it ain't gonna be like that. It ain't gonna be like that, girl. Are you serious? That's exactly what you're doing. Otherwise, it's not relevant and wouldn't even help you. And so then they point out, well, because there's a separate lawsuit. I'm sure you guys remember the Zakhanov v. Ripple case, which actually started before the SEC Ripple case. That's when that was filed. Now, I think that's going to ultimately go nowhere, but they were also claiming that Ripple was selling XRP illegally because it's an unregistered security. And I think that the lawyers over at the Zakhanov side, I think that they were really hoping that Judge Torres would find that XRP itself is a security because that would have bolstered their arguments. Instead, they got a crushing defeat, but they still haven't dropped it. which is amazing because I can't imagine this going well for them. Because there's legal precedent now, whether it's binding or not. My God, it's out there. And anyway, Attorney Morgan continues and says, Ripple sought and was granted leave to file a surreply stating the statement about the cataloging and production of Ripple of post-complaint sales in the Zakhanov matter was a misstatement, another lie by the SEC to a court. So there you go. The SEC's lying again. They said to the court, Ripple already did this work. Everything's already cataloged. All the data we're asking for, it's already part of the Zakhanov v. Ripple case. Just give it to us now. And then Ripple's like, no, that's not what happened. That doesn't. So literally, the SEC made that up and lied to the court. They asserted that it was true. They're literally lying to the judges still, even after crushing defeat, after crushing defeat, after crushing defeat. And why? Why are they doing this? Because they're a bunch of asshat pricks. It is that simple. And then Attorney Morgan says, it seems Judge Torres needs to rule on the SEC's motion to compel quickly, as the current remedies phase timetable requires remedies related to discovery to be completed by February 12th. And so, folks, that means we should expect to hear something from Judge Torres on this within roughly the next, call it roughly week and a half. And then we have this, again, the headline from the Crypto Basic, Ripple v. SEC, Deaton speaks on potential settlement, remedies, and appeal. Attorney John Deaton, a pro-XRP lawyer and founder of Crypto Law, has issued fresh comments regarding the ongoing SEC v. Ripple lawsuit. In a 22-minute live broadcast yesterday, Attorney Deaton asserted that there are no ongoing discussions about a settlement between the SEC and Ripple. He made the assertions based on the SEC's recent motion to compel Ripple to produce its audited financial statements from 2022 to 2023 and post-complaint contracts governing institutional sales. Deaton said, quote, I don't think there are any talks for a settlement. This is still scorched earth litigation, even in the remedy stage, end quote. Despite stating that the SEC and Ripple are not currently engaged in a settlement discussion, Deaton did not rule out the possibility of the case ending in a settlement. According to Deaton, the settlement can still happen in the future. Additionally, he pointed out that the SEC can still initiate a settlement if it believes it can get more from Ripple through a settlement than from what the judge could rule. And that's an interesting take there, because, and this is one of the things that Attorney Deaton was talking about. He was just noting that, this could look like just a complete embarrassment for the SEC. I mean, obviously it's already devastating for the SEC because XRP was found to be not a security by Judge Torres. That was the proper ruling, of course. But it could look even worse for them. Because think about how much money was spent, and Ripple spending $200 million roughly on all this. Who knows how much the SEC spent? And all this time waste, you know the fallout, right? And then imagine if there's a small remedy or a small settlement. And so that's why if they believe the remedy would be small regarding what would happen in court as a result of what's happening between the talks between persuasive arguments given to Judge Torres, in coming to a conclusion here, if they're afraid that the amount they'd get would be smaller, they might be willing to acquiesce on certain points in order to get a settlement from Ripple if they can get a higher dollar figure. And so that's the calculus there, potentially anyway. But here's a quote from Attorney Deaton. Maybe that will make them, the SEC, come to the table because they can spin it versus getting another ruling that embarrasses them as an organization. I'm not saying a settlement can't or won't happen. I'm just telling you it's not happening today, end quote. Ripple has always mentioned that it is open to settling with the SEC as long as the regulator provides clarity for XRP. However, the commission has not shown signs of agreeing to settle with Ripple. The lawsuit is currently in the remedy stage. Oh, actually, let me say something on that real quick, though. Ripple no longer has quite the same incentive to settle. So if it was before Judge Torres found that XRP was not a security, in order for Ripple to have that taken off the table so you don't have to risk Judge Torres coming to a bad conclusion, back then, Ripple would have given up all sorts of stuff, huge monetary loss. They would have paid whatever it would have taken if they could just get that from the SEC. But Ripple, at this point, I don't think there's that much they're going to be willing to give because they already got the massive win. That's where the difference is at this stage in the game. We're at the remedies portion, son. Anyway, Peace continues. The lawsuit is currently in the remedy stage where the court will determine the appropriate fine Ripple would pay for its institutional sales violation. It is worth noting that this violation involves the sale of over $700 million worth of XRP to institutional clients. With the SEC requesting Ripple's audited financial statements and post-complaint contracts, there are speculations that the SEC wants to include other institutional-related XRP sales that took place after the complaint was filed on December 22, 2020. However, Deaton said the SEC's biggest fear is Ripple showing an exemption to the vast majority of those institutional sales. Per Deaton, Ripple can demonstrate that the majority of its institutional sales were made to accredited or sophisticated investors. If this happens, Deaton speculated that the crypto payments company might be required to pay between $10 million and $100 million as a fund. And so, folks, to be clear, he didn't say that he was confident. He was more so trying to share a concept rather than saying he thinks for sure or highly likely it's going to be between that $10 million and $100 million fine level. He was just trying to get an idea across that there's a chance that it could be relatively small. Piece continues. Notably, Deaton asserted that Ripple could pay a significantly lower amount as a fine compared to what the company spent as legal fees defending the case. As reported earlier, Ripple CEO Brad Garlinghouse disclosed that the company has spent $200 million in legal fees since the lawsuit started. Quote, I believe the fine will be significantly less than what they spent in legal fees, $200 million. The SEC thinks that too, and they fear it. That's why they are going all out and wanting to know all the other sales and transactions. End quote. Trying to find something, I just don't see how it's ultimately going to help them here. Anyway, and then the piece wraps up by stating, commenting on the possibility of the SEC's appealing Judge Annalisa Torres' summary judgment decision, Deaton asserted that the Second Circuit would not overturn the ruling. He noted that Judge Torres' decision on Ripple programmatic sales and other distributions of XRP, which he found to be non-securities, were based on the third factor of the Howey test, expectation of profit. However, if the Second Circuit remanded the case, Deaton speculated that Judge Torres would still issue a similar ruling based on the second factor of the Howey test, common inverse. Yeah, and so what there's, just to make sure that's understood, when Judge Torres ruled on the Howey test here, she looked at one prong. That was it. Expectation of profit. So, if there's an successful appeal and then it's thrown back to her, all she has to then do is rule on another prong of the Howey test. She left this open for herself. She knew what she was doing. So if the SEC comes, and the SEC knows this too, so if it's thrown back to her, which is it's highly unlikely already, but if it happens, she's just going to come back and be like, well, there's no common enterprise. And then they lose anyway, obviously. So not that it would even come to that. And then Attorney Deaton also did speak in this live broadcast about what might happen in terms of XRP price, and I'm kind of with him in what he said, because he just is like, yeah, I mean, I don't know what's going to happen. That's what he said effectively. He's like, is it going to cause the price of XRP to run? Well, and and it's funny because a few days ago I was talking about this myself, and I was like, well, I mean, it's possible I'll cede that point, but I'm actually kind of skeptical that it would run. Does anybody care at this point? Like, given that XRP already has legal clarity, if there's a settlement or when the news comes out, whatever Ripple's going to have to pay, presumably they're going to have to pay something in the remedies phase here. In either of those scenarios, are global XRP markets going to care in terms of the way they speculate? I'll say maybe, but I find it honestly kind of unlikely. What do you guys think? Like, to me, I just don't see why they'd care, because it doesn't have a material impact one way or another on XRP. That's why I just want to say, no, it doesn't make any sense. Unless the market's going to be completely illogical, which it can be. So, I mean, I guess there's that here. But ultimately, Attorney Deaton was like, I don't know. And see, that's my answer too, honestly. I don't know. I just have like a for fun guess. I lean one way, which is I don't think it's going to matter in the end. And so that's what's up next for XRP holders. We just have to kind of wait and see if there's a settlement and if that has an impact. But I'm still skeptical that there would be any sort of notable impact, if any detectable impact at all. But you guys can tell me what you think in the comment section below. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.